Hello, everyone, and welcome to Uncivil Law. And for today's case, we have a situation with a credit reporting agency. You know, these agencies that report your credit and provide your credit report to other people. This is TransUnion, one of the credit reporting agencies. And this credit reporting agency was decided to report other things other than credit. In particular, whether or not your name was on any part of any sort of concern list that was generated by a government. I'm trying to avoid particular words here in the introduction. So if the government said that you are a person of some note, TransUnion, in their infinite wisdom as a credit reported agency, decided to put it on your credit report and tell other people about it. And they mislabeled several thousand people as being bad people when they were not bad people. And the people would like to sue for TransUnion calling them out when they weren't in fact the things that TransUnion said. So I suppose this is a defamation case. There's some class action issues here about whether or not these people have standing and stuff. So yeah, we'll get into whether or not the credit reporting agency reported some things that were not credit related that made people may have caused some people to perceive these individuals in bad light. I think I got away with that. Let's get started with this. This case asks us to resolve whether a class of consumers may sue and recover damages from a credit reporting agency pursuant to the Fair Credit Reporting Act, where the agency, aware that its practice was unlawful, incorrectly placed terrorist alerts on the front page of consumer credit reports and subsequently sent the consumer confusing and incomplete information about the alerts and how to get them removed. Yes, your credit reporting agency over here reported 8,000 people on the front page of their credit reports and labeled them as terrorists. They called them terrorists. That was the defamation. The credit reporting agency on the front page of the credit reports called 8,000 people terrorists. That's a thing that happened. Let's go further. The United States Department of the Treasury's Office of Foreign Asset Control maintains a list of specially designated nationals. Very exciting. Individuals who are prohibited from transacting business in the United States for national security reasons. Because merchants who transact with these designated nationals can face harsh fines, TransUnion, the credit reporting agency, saw a business opportunity in developing a product for its clients that matched consumer names to individuals on this prohibited list. Very good. In producing these purported matches, TransUnion coordinated with a third-party vendor and used software that conducted a basic first and last name search, despite having the capability to conduct a more accurate search and despite having been put on notice by another court in 2010 that this practice violated the Fair Credit Reporting Act. So TransUnion over here said, oh, there are penalties if you do business with someone who is a prohibited person. What if we told people who are prohibited persons? And how are we going to determine if someone's a prohibited person? I know. We'll just do a simple first and last name search. So if someone is on the bad list and you have the same and first and last name as that bad person, you must be that bad person. And we are going to look absolutely no further into it beyond that. Way to go, TransUnion. That was a good idea, especially after being notified by a different federal court that its practices were illegal. It continued to do it anyway. Great. That's wonderful work there. The consumers that brought this action against TransUnion pursuant to the Fair Credit Reporting Act, and a jury assessed $60 million in damages for 3 willful violations of the law. In this appeal, TransUnion claims the verdict cannot stand because only Sergio Ramirez, the representative plaintiff, suffered a concrete and particularized injury as a result of the unlawful practice. No one on this earth knows what the YouTube algorithm does. No one on this earth understands the YouTube algorithm or what it does because YouTube doesn't tell you. So yes, yours truly is taking a shot in the dark and guessing at the YouTube algorithm like every freaking one else. But this is what I'm reduced to. I'm reduced to trying to figure out in the first 30 seconds how to phrase things when I have really contentious cases, when I'm discussing things like rape and sexual assault. And so I have to come up with different wording and different word choices because YouTube hates me. Because YouTube doesn't want to discuss serious things. So, yeah. According to TransUnion, the other thousands of class members whose credit reports contained the inaccurate terrorist alerts and refused confusing and incomplete mailings did not suffer harm. So the other people, the other 8,000 people, they didn't suffer any harm. So, we may have done a bad, but they didn't suffer any penalty from our bad. That was TransUnion's claim. Ramirez, on the other hand, claims the class members do not need to demonstrate standing at all because in class action, only the representative plaintiff must have standing. The issue of who must show standing in a class action at the final stage is a question of first impression. So the first issue we have to get to is standing. Who has standing to bring this complaint? You have to have standing, and who has to have standing in the complaint? So we have a class action, which is a group of people who in the class must have standing. And it's especially at the point of final judgment. So because you can lose standing along the way. So if you're an individual and you lose standing along the way for some reason, well, you're just done. So the question is, who has to have standing at the end? Some of the members, all the members, we don't know. So the court now has to figure that out. For the reasons explained below, we hold that every member of a class certified under the rule must satisfy the basic requirements of standing at the final stage of monetary damages when class members are to be awarded individual monetary damages. So if we're giving individual people money, those individual people, no matter how many there are, must have standing, which makes perfect logical sense. Therefore, the dispositive question is whether each of the 8,185 members have standing on the claim. So do all of them have a complaint? Another way of phrasing that was, if all 8,000 of them were here individually, could all 8,000 of them get money? Could all 8,000 of them have standing? We conclude that they do. So yes, all 8,000 of them have in fact been injured. All 8,000 of them, if this were individual, could bring this lawsuit. So they're bringing it collectively, and yes, they can get their money. So yay. So having decided that all 8,000 people can sue, we should probably discuss what happened to at least one of them. So let's discuss what happened to the chief representative, the class representative, Ramirez. What happened to him in sort of this alert, and how is TransUnion conducting its business practice? So let's discuss the individual case that is Ramirez. In February 2011, Sergio Ramirez went to a Nissan car dealership with his wife and father-in-law to purchase a car. After the Ramirez's selected a car and negotiated on the term, the dealership ran a joint credit check on Ramirez and his wife. But once the dealership obtained the credit report, the salesman told Ramirez that Nissan would not sell the car to Ramirez because he was on a terrorist list. So he can't get his Nissan. That's very, very sad. The credit report had been prepared by TransUnion, one of the nation's 3 largest reporters. The report contained the following statement on the first page of the report. OFAC Advisor Alert. Input name matches name on OFAC database. The report also lists the names and birth dates of 2 prohibited specially designated nationals who purportedly matched Ramirez, Sergio Ramirez and Sergio Ramirez. So there's 2 different people with 2 different birth dates. The report indicated that Ramirez's middle initial was L and his birth year was 1976. The salesman refused to take further steps to verify whether Ramirez was in fact on the list, which I'm not even sure what those steps would be in principle. But I wouldn't know what to do. So he refused to take further steps like what? I don't know. He also refused to provide Ramirez a copy of his credit report, which is a no-no. You can't do that. And incidentally, under the Fair Credit Reporting Act, if you're denied credit based on a report, you have to be provided the report. So yeah, that's a no-no. You can't do that. So the dealership violated the Fair Credit Reporting Act because they have to provide him a copy of the report. Instead, he suggests that Ramirez contact TransUnion directly. Actually, now that I think about it, I'm not sure if the dealership is under the obligation to do it themselves or TransUnion has to do it. I know someone has to give them a copy of the report, so I take that back. Maybe the dealership wasn't in violation. I'd have to go reread the Fair Credit Reporting Act. Someone has to do it. I'm not sure if it's the dealership, though, but either way. Eventually, however, the salesman agreed to sell the car to Ramirez's wife, which is hilarious. Ramirez's wife completed the credit application on her own, and after another, she was able to purchase the car. So initially, they did a joint credit report, and they said, "No, we won't sell it to you because you're on a watch list." How about my wife? My wife isn't on a list. So then they just did the wife's name separately, and they sold her the car. So our terrorist friend over here got his Nissan after all. So yay. Confused and not knowing what to do, Ramirez began researching what the alert meant and how to have it removed. Ramirez first called the Department of the Treasury, but they first advised him that he'd need to contact TransUnion. When Ramirez contacted TransUnion, he was repeatedly told there was no alert on his credit report. Ultimately, Ramirez requested a copy of his report so he could verify whether it contained an alert. So when he called them and said, yeah, there's no alert on your credit report, that's pretty odd because they told me it is. Can I get a copy? Sure, if you pay us $50 or whatever it is. So he paid his $50 or whatever, and they sent him a copy of his report. Again, having been denied it on the basis of report, he's probably entitled to get it for free, but I'm sure he paid. But anyways, yeah, he got a copy of his report. Having obtained his credit report, the credit report contained no mention of this designation. Ramirez was confused by the lack of information, but he thought perhaps the problem had been resolved. So he got a copy of his credit report and it didn't contain this information. However, the next day, TransUnion sent a separate letter, the Ofac letter. The Ofac letter states the following: "Thank you for contacting TransUnion. Our goal is to maintain complete and accurate information on consumer credit reports. Our records show that you've recently requested a disclosure of your TransUnion credit report. That report has been mailed to you separately. As a courtesy to you, we also want to make you aware that the name on file appears to be Sergio L. Ramirez and is considered to be a potential match to information listed on the United States Department of Treasury's Office of Foreign Asset Control database. The OFAC database contains a list of individuals and entities that are prohibited from the United States Department of Treasury from doing business in or with the United States. Financial institutions are required to check customers' name against the OFAC database and, if a potential name match is found, to verify whether the potential customer is a person on the OFAC database. For this reason, some financial institutions may ask for your date of birth, or they may ask to see a copy of government-issued identification. Some financial institutions will search names against the database themselves, or they may ask another company, such as TransUnion, to do so on their behalf. We want you to know that this information may be provided to such authorized parties." Well, the warmness of my heart feels total relief, guys. I feel very satiated by this wonderful memo telling me that I'm a potential terrorist and people will be told about it. I feel validated in every possible way. Thank you for the warm letter, TransUnion. Ramirez testified that he was confused by these two mailings. The lack of any OFAC information on the credit report mailing suggests the alert had been removed, but the mailing letter had suggested otherwise. Ramirez was not the only consumer who TransUnion incorrectly labeled as being a prohibited person. TransUnion sent the same letter to 8,184 other consumers who also requested copies of their report between January and July of 2011. In February of 2012, Ramirez sued TransUnion on behalf of himself and the other 8,184 consumers who were falsely labeled. Having heard the story of Ramirez over here, we must now learn how this whole program came to be. How did TransUnion decide that this was a good idea? Let's learn more about how TransUnion, in their wisdom, decided this was a good idea. This class traces its claim back to TransUnion launch of a new product in 2002, and its erroneous belief the new product was exempt from the Fair Credit Reporting Act. TransUnion saw a business opportunity because its clients, who purchase consumer credit reports from TransUnion because they're deciding whether to offer credit to consumers, are legally obligated to ensure they're not offering credit to a prohibited person appearing on the list. TransUnion therefore developed a product called an advisor, which added an alert to the consumer report indicating whether the consumer was a prohibited person. TransUnion obtained the information about whether consumers were matches from a third-party company, Actuity. Actuity software consisted of a name-only search consisting of a first and last name. A name result would match even if the name was close. For example, for alternative spellings of Cortez. So not only were they doing a first and last name search, they were also matching you against closely matched names. So that was super positive. TransUnion also adopted a policy of not disclosing OFAC matches to affected consumers when consumers requested a copy of their report. Although TransUnion received a number of consumer complaints after it launched the advisor and adopted these policies, TransUnion remained mostly unscathed until 2005 when TransUnion was sued for the first time. This is not the first time this has happened. In 2005, Sandra Cortez, a consumer, sued TransUnion in Eastern District of Pennsylvania under circumstances that were similar to Ramirez's. On appeal in that case, TransUnion argued that the OFAC information was not covered by the Fair Credit Reporting Act because it was not part of the consumer report as defined by the statute. In August of 2010, the Third Circuit flatly rejected this argument, noting that it was difficult to imagine an inquiry more central to a consumer's eligibility for credit than whether federal law prohibits extending credit to the consumer in the first instance. So, TransUnion over here said we don't have to disclose it because it doesn't go to whether or not you can be offered credit. And the federal court is like, what are you talking about? That's exactly the reason it's being offered in the first place. Of course it does. You have to include it as part of the credit report. And then did TransUnion change its policy? No, that would have been way too logical. I don't know what their corporate lawyer over there was doing, but not looking too positive, man. With respect to Cortez's claim, TransUnion willfully failed to disclose all the information when they requested it. TransUnion argued that this information was not part of the consumer's file, which is another trick, because TransUnion did not store the information in its usual database. So yeah, it's not part of our file because we didn't keep it in the same place. That's definitely a good idea. Rather, it contracted with Acuity to store the information separately. The Third Circuit rejected this argument, this shuffling. We do not believe Congress intended to allow credit reporting companies to escape the disclosure requirement simply by contracting with a third party to store and maintain information that otherwise would be part of the consumer file as included in the report. So yeah, it's like, yeah, we didn't have the information. It's like, no, that's not going to fly either. So they were on notice that this was illegal, but they kept doing it anyway. After being slammed with a jury verdict in the Cortez case, TransUnion made surprisingly few changes to its practices regarding these alerts. In November 2010, TransUnion changed the language of the alert on the credit report. Instead of saying that a consumer was a match, the report would say a consumer was a potential match. Well, that's definitely a huge difference. TransUnion also made some adjustments to its matching algorithm. Within the time frame of the litigation, TransUnion received warning about its practices from officials at the Department of Treasury. So even the Department of Treasury is saying you should stop doing this. The U.S. government is saying you should stop doing this. So both a federal court and the executive branch are saying you should stop doing this, and they kept doing it. Not great. As a result of these warnings, they changed how that was communicated. That was definitely what they were doing. Between January 2011, when consumers flagged it, TransUnion would send them 2 copies. They'd send them a report with the OFAC redacted and also a separate letter. So having received warnings from both the federal court and the executive branch Department of Treasury that they should just stop, they said, what if instead of stopping, we just send a separate letter saying that we're continuing to do it? How about that? Is that the same thing as stopping? I hope that's the same thing as stopping, says TransUnion. Good. Based on the TransUnion records, the parties stipulated that there were 8,185 consumers, including Ramirez, who fell within this category. The records reflect that 1,853 had credit reports requested by a potential credit guarantor during the class. TransUnion did not furnish the parties the reports to third parties for the remaining of the class members. And the jury that heard this case decided that, yeah, there should be monetary damages, awarding about $60 million in total. So the jury said, yeah, there's a bad thing that happened here. Okay, so having decided that there was a bad thing that happened here, we now have to get to the exciting issue of standing. Because we have to decide whether or not the people have the right to sue. Were you harmed? Is there something a court can do about it, and so forth and so on? So now let's figure out whether 8,185 people have standing or not. So let's figure that out. All right. TransUnion first argues the verdict cannot stand because none of the class members other than Ramirez have standing under the Constitution. Really? Standing is an essential and unchanging part of Article 3. Yes, it is. The irreducible constitutional minimum of standing requires a plaintiff to establish these things. The plaintiff must have suffered an injury that is concrete. There must be a causal connection between the injury and the conduct, so what we did caused the problem, and it must be likely that the injury can be redressed. So it must be possible for the court to do something about it. You've been hurt by something we did, and there's something a court can do about it. That's standing. The parties first dispute who must demonstrate standing to recover damages, only the class representative or every class member. This court has previously held only the representative plaintiff need to allege standing at the motion to dismiss and class certification stages, and even at final judgment stage in class actions involving only injunctive relief. But we've never addressed the question of who must have standing at the final stage of monetary damages when class members are to be awarded. So if the person was moving for a motion to dismiss or summary judgment, they can do it. If it's merely injunctive relief, then fine. But if it's monetary damages, we've never addressed that question. Do they have to have standing or not? Okay. We address that question today and hold that each member of the class must satisfy the bare minimum of standing as final judgment stage in the class action in order to receive monetary damages, which for me makes perfect logical sense. A class action is merely a convenient thing that is functionally, although the degree to which it's functionally the same is debatable, but it is somewhat akin to all the people suing individually, but in a much more convenient way. That's kind of what a class action is. So you can't be a member of a class if you don't have standing. That doesn't even make sense. And so the court here saying, yeah, you have to have standing at the end because nothing else would make any sense. You can't get money damages if you don't have standing. And if you lose standing along the way for some reason, then you lost standing. If you never had standing in the first place, you don't have standing. So yeah, in order for you to be impacted by this, you have to have standing. So it makes perfect logical sense. So yes, all 8,185 people have to have standing. Internet commentator asked me, are class actions consolidated cases? No, it depends on what you mean by a consolidated case, internet commentator. Normally when we say a consolidated case, what we mean is that the cases were filed individually by a whole bunch of people. And then at some point a court consolidated them. So they merged the cases themselves. So you depending on your point of view, you can think of a class action where the merger was done up front instead of by the court. So typically when you talk about a consolidated case, there was a bunch of individual cases filed that were then forced to be consolidated. So this would be being done up front. So is that the same thing as a consolidated case? I don't know. It depends on your perspective. But you can treat them as similar to a consolidated case. At least logically, it makes sense to me. Having concluded that each member must have standing to recover damages, we turn to the dispositive and more difficult question. Did everyone have standing? TransUnion challenges only the first standing requirement, injury in fact, so that you have been injured. Because a plaintiff must demonstrate standing, we address the standing for each of the class. Plaintiff bore the burden of proving standing through evidence at trial. So you must prove your TransUnion argues that to suffer a concrete injury from the violation, each class member must show that TransUnion disclosed his or her credit report to a third party. In other words, TransUnion asserts no injury results from a false alert unless someone other than TransUnion and the consumer sees it. The Supreme Court, however, has recognized an injury may be concrete even if it's intangible, and that there can be sufficient injury in fact when a defendant's statutory violation creates a risk of harm of concrete injury. We have held that the Fair Credit Reporting Act was enacted in part to protect consumers' concrete interests in avoiding very real-world harms that result from inaccurate credit reports, such as the inability to obtain credit and employment and the uncertainty and stress that consumers experience when they discover inaccurate information in their credit reports. We noted that these interests that the law protects also resemble reputational and privacy interests that have long been protected at law. We have also concluded that they're in the prior case that they had been exposed to a material risk of harm to that concrete injury because a published information exposed on its website was far more material than a mere incorrect zip code. Applying that fact to the facts of these cases, we conclude that all the class members suffered a material harm to concrete interests protected by the statute as a result of the failure to provide reasonable protections to assure a maximum possible accuracy of information. Finally, TransUnion, one of the nation's largest consumer reporting agencies, made all its class member reports available to potential creditors or employers at a moment knowledge, sometimes even without knowledge. Yeah, sometimes they're running knowledge, sometimes they're running credit reports and giving it to people even you don't even know about it. Credit reports exist for a variety of purposes being disseminated to third parties. Like in the prior case when false information was made available to third parties, TransUnion created a real risk of harm by allowing class members to allow third parties to readily access those reports. So it was an imminent enough harm because you made them readily accessible. So even if you didn't share it, it could have been shared at any time. You made them readily accessible, so that's an imminent enough injury, I suppose, to get standing. So it works for me. Here, the fact that TransUnion made the reports available to numerous potential creditors and employers, coupled with the allegedly sensitive and distressing nature of the alerts, they're a little bit sensitive. Disclosed to the consumer the risk of third-party access created through its dealings and the federal government's awareness of the alerts is sufficient to show a material risk of harm to the concrete injuries of all the class members. We are not faced with a mere technical or procedural Fair Credit Reporting Act violation. There may be a case where the nature of inaccurate information is such that no risk of harm arises until the credit information of all class members is actually disseminated to the third party, but this is not that case. On the facts of this case, we hold a real risk of harm arose when TransUnion prepared inaccurate reports and made them readily available to third parties, and certainly once TransUnion sent inaccurate information to the class members, and some class members' reports were disseminated to third parties. The risk of harm was directly caused by TransUnion failure to follow reasonable procedures to ensure maximum possible accuracy of the information, and an award of damages would redress the harm caused by this risk. We have no trouble concluding that TransUnion's disclosure violations exposed all class members to material risk of harm to their concrete informational interests. TransUnion sent the class members a document that purported to be their entire credit report, containing no mention of the alert. This put every class member at real risk of harm, not knowing that they were falsely being labeled as terrorists, drug dealers, and threats to national security. Then, TransUnion sent the class members the separate Ofac letter without a summary of rights form. This conduct posed a serious risk that consumers would not only be unaware this damaging label was on their reports, but also be left completely in the dark about how they could get the label off their report. TransUnion's conduct therefore exposed every class member to a material risk of harm to the core interests the Fair Credit Reporting Act was designed to protect, their interest in being able to monitor their credit reports and promptly correct inaccuracies. So that is the end of the case of Sergio Ramirez versus TransUnion. So we learned all about how TransUnion, one of the major credit reporting agencies, did an oopsie. They did an oopsie by having been informed by a court of appeals that what they were doing was bad, and having been informed by the Department of Treasury that what they were doing was bad. They continue to do it anyway. They continue to notify credit reporting, they continue to notify people asking credit reports, except the consumer for some reason. They let people know who were terrorists even though they weren't terrorists. And they determined they were terrorists by whether their name was the same or even close to it. So 8,000 people were impacted by this. So yeah, TransUnion did an oopsie by knowingly and purposefully, in defiance of a court and defiance of the executive branch of the government, labeling 8,000 people falsely as terrorists. So yes, these people have standing. Yes, TransUnion can be held responsible. And that is the end of the coverage of this case. Thank you for joining me as we both read this case together and now better understand the law. If you're enjoying this legal education content, please subscribe to this channel. It really helps us grow. And check out one of our other videos, including the one that's currently being displayed on the thumbnail on screen. Thank you so much for your continued support. Until later, my friends, cheers and goodbye.